I'm Andy Hill, Head of Secondary Markets at ICMA. Thank you for joining this webinar on the ICMA Buy-in Rules. To kick off, I'm going to hand over to Lee Goss, our legal counsel, who will introduce the rules.
Just to give some legal and historical context, the average person might be surprised by this, but the failure to deliver bonds does not give the parties the right to cancel the trade. On the contrary, the expectation is to fulfill the bargain as originally agreed. And so the practice of buy-ins has long been established to cure the defect in the failed delivery. And under the ICMA framework, we provide a very cost-efficient and quick method of resolving settlement fails. Under the buy-in framework, it gives the buyer that's not received the bonds the right to self-help, to basically cover the failed delivery by buying the securities elsewhere in the market and settling at any market price difference with the seller. Next slide, please. So ICMA, unlike a lot of other trade associations, actually has rules that applies to its members. And this applies to trades between members, whether they're acting as principal or agent in international securities. And trades between a member and a non-member, or trades between two non-members, also can be subject to the secondary market rules of ICMA, provided that the parties have agreed in writing before the transaction. Next slide, please. So under the rules, cash secondary market trades in bonds are subject to the rules and subject to the buy-in rules. Excluded from the rules are primary market transactions, syndication and allotments, and repo transactions. Next slide, please. So basically, any international security means a bond that can be traded cross-border and is also subject to an ICSD's regime or settlement. Next slide. Over to you, Andy.
Thanks, Lee. What is a buy-in? So buy-ins are used to manage counterparty risk arising from a settlement fail, and they do this by enforcing settlement. In the event of a settlement fail, a buy-in mechanism provides the disappointed buyer of securities with the option to purchase the failing securities from a third party. This replaces the delivery obligation of the failing seller. Buy-ins are usually a contractual right of the non-failing party, and importantly, are not an obligation. The difference in the cash value between the buy-in, the replacement trade, and the original failing transaction is then settled between the counterparties, along with any reasonable direct costs incurred by the disappointed party in executing the buy-in. The reason for this is to ensure that the disappointed party is returned to the same economic position they would have been in had the original transaction settled as intended. Underlying this is the principle of symmetrical payments, meaning that the payment between the parties can go in either direction, depending on whether the buy-in value is higher or lower than the original transaction. While the failing party will usually incur a cost from being bought in, buy-ins are not intended to be a penalty or compensation mechanism. In fact, from the perspective of the disappointed party, buy-ins are economically neutral. Next slide. Other key features of a buy-in mechanism include the principle of guaranteed delivery. This is to ensure that successful settlement of the buy-in occurs and to minimize the risk to both parties. It is usual for the disappointed party to provide the failing party with notification of the intention to execute a buy-in with a specified buy-in date. This will usually allow enough time for the failing party to attempt to source and settle the securities before the buy-in is actioned. And this is in the form of a buy-in notice. Also, buy-in mechanisms usually have what's known as a pass-on mechanism. And this provision allows for a buy-in to be passed along a failing settlement chain. This provides for a single buy-in to remedy multiple dependent fails. Next slide. So who initiates and executes a buy-in? Well, there are a number of considerations underlying this. First of all, initiating a buy-in is a commercial decision. since it could result in a cost, sometimes quite significant, for the failing party. Buy-ins are also a risk management decision, since fails can result in counterparty credit risk for the disappointed party. Buy-ins are also regulated market transactions. Buy-ins create market risk for the failing party, and buy-ins require timely communications between the effective traders of both parties, as well as the relevant operations teams. It is also important that parties adhere to the contractual provisions of the buy-in process. So essentially, the buy-in process is generally managed by the relevant trading desk. Buy-ins are trades involving market risk. However, it will also usually involve risk managers, legal, and operations teams. Next slide. The process for buy-ins under the rules is outlined in section 450 of the rulebook, and we will spend the next few minutes looking at those provisions. Issuing the buy-in notice. This is outlined in Rule 451. Essentially, the notice must be in writing, which includes email. Importantly, it must be issued before 10 a.m. London time. Pass-on notices must be issued immediately upon receipt of the buy-in or a pass-on notice. Some considerations. When issuing a buy-in notice or pass-on, it is advisable to request acknowledgement of receipt. Also, on receiving a buy-in or pass-on notice, it is important to notify the relevant trading desk immediately. Remember, these involve trading risk, market risk. Next slide. Selecting the buy-in date. The buy-in notice details are outlined in Rule 451(3). Essentially, the issuing party must select and communicate the buy-in date. The execution of the buy-in transaction should commence on this date. Under the rules, the buy-in date can be a minimum of 4 business days from the notice date and a maximum of 10 business days. Once notified, the buy-in date cannot be changed once it is communicated. The specified buy-in date will remain the same in any subsequent pass-on notices. Something very important to note. Next slide. So what information goes in the buy-in notice? Again, this is outlined in the rules under 451.4. Essentially, this is the intention to buy in, the buy-in execution date, details of the transaction being bought in, including trade date, settlement date, nominal, security description, price, value, delivery, settlement details, etc. And also whether it is a pass-on situation. Next slide. Delivery during the buy-in notice period. This is outlined in Rule 456 and covers partial delivery. Essentially, following the buy-in notice, the failing party can continue to attempt to settle part or all of the failing trade. The disappointed party should receive any partial settlement and reduce the amount of securities to be bought in accordingly. Partials should be accepted on the condition that the residual buy-in amount is a tradable lot, and any attempt to settle on or after the buy-in date should be notified in writing the day before and accepted by the disappointed party. Important to note, it is advisable that both parties put their settlement instructions on hold from the buy-in date. Next slide. Buy-in execution. The rules around the execution of the buy-in are outlined in Rule 454. Next slide. To summarize these, firstly, best execution. The executing party should, acting in good faith, attempt to execute in the best available market for normal value date for part or all of the buy-in amount, taking into account factors such as price, cost, size, and liquidity. This is intended to protect the failing party. Conflicts of interest. The disappointed party initiating the buy-in cannot use any of their own inventory or that of an affiliate to settle the buy-in, whether directly or through an intermediary. Guaranteed delivery. The buy-in should be executed for guaranteed delivery. This allows for the buy-in to be completed in part or full at the moment of execution and not be dependent on successful settlement, thereby ensuring certainty of outcome for both parties. It is likely that the party selling into the buy-in will require an additional premium to the current market price as compensation for guaranteed delivery. Notification of execution. The failing party should be informed immediately following the successful execution of part or all of the buy-in, ideally at the trading level. This minimizes the market risk of the failing party and allows them to hedge or trade out of their resulting change in position before any movement in the market. Next slide. Reasonable direct costs. Any reasonable direct costs incurred by the disappointed party arising from the buy-in execution, such as brokerage fees, buy-in agent spread or fees, trading venue costs, etc., should be included in the final buy-in value when settling the difference between the buy-in and the original transaction value. Unsuccessful completion. If part or all of the buy-in cannot successfully be executed on the specified buy-in date, the disappointed party may elect to continue working the buy-in on subsequent days until the buy-in is fully executed. However, it is advisable for the disappointed party to communicate to the failing party at the end of each day their intention to continue working the buy-in on the subsequent day. The disappointed party may elect to discontinue working the buy-in at any stage. However, in this case, they should inform the failing party. Should they subsequently choose to continue the buy-in, they will be required to begin the buy-in process again and issue a new buy-in notice with a new buy-in date. Alternative settlement. If the buy-in cannot be completed successfully, both parties may elect to negotiate an alternative remedy, such as cash settlement. Note that the rules do not provide any mechanism for alternative settlement. This has to be negotiated by the parties. Next slide. Confirmation of the buy-in execution. This is outlined in Rule 457. But important notes to take away. Following the successful execution of part or all of the buy-in, the disappointed party should notify the failing party of relevant details, essentially quantity and price, immediately. This should be in writing, which could be mail or electronic messaging. It is advisable to communicate this at the trading level and possibly also to do so by phone. This should also apply in the case of a pass-on situation so that notification is passed along the chain, again, immediately and ideally at the trading level. The disappointed party should also provide the failing party with a confirmation note, ideally on the same day. Again, this should be passed along any pass-on chain. Next slide. Pass-ons. A pass-on situation can arise where a party is failing to settle a sale as a result of a failing purchase, and where both transactions are subject to the rules. A party that finds themselves in a pass-on situation on receipt of a buy-in or pass-on notice should immediately pass this on to their failing counterparty, including in the notice that this is a pass-on situation. The buy-in date specified in the original buy-in notice cannot be changed. The same buy-in date will apply for each pass-on notice. Where a pass-on chain is particularly long or crosses multiple time zones, it is possible that by the time the notice reaches the final failing party in the chain, the buy-in date may be less than the minimum 4 days specified in the original notice. It's advisable that from the buy-in date, parties in a pass-on situation put their settlement instructions on hold and only accept partial or full delivery subject to their other counterparty also accepting delivery in accordance with the conditions outlined in the rules. Next slide. Pass-on execution. On receiving notification of the execution of part or all of the buy-in, a party in a pass-on situation should notify their failing counterparty immediately. Again, any communication should be in writing and ideally at the trading level. Additional communication by phone is also advisable. The buy-in confirmation note, which includes the details of the buy-in execution, including price and size, should be passed along the buy-in chain promptly. Note that this price will be used to settle the pass-on payments between respective counterparties in the pass-on chain. Next slide. Settling the buy-in. The provisions for this are outlined in Rule 458. But essentially, the cash differential between the value of the buy-in, including accrued interest and any direct costs, and the original transaction is settled between the failing and disappointed parties. As mentioned previously, the payment can go in either direction, depending on whether the value of the buy-in, including costs, is higher or lower than the value of the original transaction. This differential should be settled as soon as possible after the buy-in execution. In a pass-on situation, the difference between the buy-in value, including costs, and the original transaction value should be settled between the parties in the chain and their respective counterparties. Again, using the same buy-in price plus costs that's in the buy-in notice. Next slide. Here we provide some examples of how the buy-in is settled. Take a very simple trade. A sells to B some bonds, 100 bonds at a price of $98.50. A fails, B issues a buy-in. They buy the bonds at 99, which is 50 cents higher. A will then make a payment of 50 cents to B to compensate them for that difference. If, however, the market has dropped and B buys the bonds at 98, then that 50 cents differential between 98.50 and 98 is actually paid by B to A. But what you can see here is that B is in exactly the same economic position it would have been in. Next slide. Again, a pass-on situation showing higher prices, lower prices. And again, I won't run through all the details here, but if you take time to look at the deck, you will see that the transactions between each counterparty and the buy-in price, which is the single buy-in price, determine the differential to be paid by every party in the chain. Next slide. There are some exemptions from buy-ins under the rules. These are outlined in Rule 459. But essentially, securities that have been redeemed in their entirety cannot be bought in. Transactions not subject to the rules also cannot be bought in. These include primary market transactions, documented securities financing transactions, such as repurchase agreements, and transactions subject to the rules of an exchange. Transactions not executed under the rules or where the buy-in rules have been specifically disapplied are also not subject to the ICMA Buy-in Rules. Next slide. Occasionally, disputes do arise from a buy-in, and some of the examples of where this can happen are outlined here. Firstly, non-adherence to the rules, where the disappointed party has not followed the relevant rules specified in the rulebook, including those pertaining to the buy-in notice. The failing party may have a case to reject the buy-in. Sometimes disputes arise around the buy-in price. In some cases, the buy-in price may be significantly higher than the understood market price. As explained earlier, this could be the result of any premium for guaranteed delivery, as well as poor market liquidity. The executing party should be able to evidence that they have executed the buy-in to the best of their ability in compliance with Rule 454.1 and the best execution guidelines outlined there. Conflicts of interest. The disappointed party should be able to evidence that they have not used their own inventory or that of an affiliate to settle the buy-in. Finally, arbitration. While buy-in disputes sometimes occur, it is extremely rare that firms seek recourse in litigation or alternative dispute resolution. ICMA's experience is that most disputes can be resolved successfully by negotiation between the affected parties. particularly at a senior commercial level. Next slide. It's worth mentioning sellouts. While a lot rarer than buy-ins, the rules also contain the provisions for a sellout, and these are provided under Rule 481. In a sellout, the disappointed seller has the right to sell the securities to a third party, and for any difference between the value of the sellout and the original transaction to be settled between the seller and the original buyer. The sellout rules effectively mirror the buy-in rules, including with respect to the sellout notice, partial settlement, execution, pass-ons, and settling the sellout. These can be found, as mentioned, in section 480 of the rules. Next slide. So, to sum up, issuing a buy-in notice has to be done by 10 a.m. London time, and it must specify the buy-in date, which can be from 4 to 10 business days following the notice date. Pass-ons are to be forwarded immediately, noting that the buy-in date cannot be changed. While the buy-in notice is in force, partial or full delivery can be accepted provided the seller advises the buyer in writing at least 24 hours in advance of any such delivery intended to be made on the execution date of the buy-in. It is also advisable for parties to put settlement instructions on hold from the buy-in execution date. The buy-in execution is to be communicated to the failing party and along any pass-on chain immediately, ideally at the trading level, and this includes any partial executions. The buy-in confirmation note is to be issued to the failing party promptly and again along any pass-on chain. And the buy-in differential is settled between the parties, including those in a pass-on chain, without delay following successful execution of part or all of the buy-in. Next slide. As a final point, it's worth mentioning the EU CSDR mandatory buy-in provisions. While it was never implemented, the EU did pass into law a controversial mandatory buy-in regime as part of the CSD regulation in 2014. The regime was intended to make buy-ins a legal requirement in the EU rather than a contractual right, and would be applied at the CSD participant level rather than at the regulated entity level. The implementation of the MBI regime has been delayed several times, ostensibly due to timing issues, but ultimately the result of recognized design challenges, a lack of market preparedness, as well as concerns about the impact on market liquidity. In 2022, as part of the targeted CSDR review, the European Commission proposed an alternative two-step approach to MBIs, which would only be applied in specific markets where settlement efficiency rates were of concern or threatened to undermine market stability. During the 2023 trilogue process, the European Council and Parliament added even more stringent requirements before MBIs could be applied. In reality, it is not expected that MBIs will ever be implemented in the EU. There are still a number of design challenges that potentially render them inoperable, as well as implementation challenges relating to the contractual arrangements which are required to make them enforceable. In the meantime, contractual buy-ins, such as the ICMA Buy-in Rules, continue to play an important role in managing counterparty credit risk in the event of fails, as well as supporting settlement efficiency, not only in the EU, but across international bond markets more widely. Next slide. Thank you for your time and attention. We hope that this was helpful. If you do have any further questions about the buy-in rules, then please do not hesitate to contact us here at ICMA. Contacts are available in the deck. And of course, you can always use the legal help desk hotline, where we stand by ready to answer any of your questions. So on behalf of Lee and myself, thank you.